everybody hear me in the back okay? Okay, if I get a little excited and I start speaking too loudly, just somebody motion to me, because, you know, sometimes I get a little carried away and that gets embarrassing, you know, when, like, you've spoken to a jury for, like, 3 days and then, you know, you're talking to them afterwards, they're like, you talked really loud sometimes. It really bothered us. So don't let me get to that point. I like to, whenever I'm giving any kind of presentation like this, kind of disclose a little bit about my biases, because we're talking about topics that reflect government and the role of government. So I always think it's most respectful to your audience if you disclose your biases rather than trying to really artificially pretend like you're this objective machine. So I am the vice chair of the Johns County Democratic Party. I'm on the state committee of the Kansas Democratic Party. I was an alternate delegate for Bernie Sanders, worked on Democratic campaigns, so those are my biases. Do with that information what you will. Today is an educational event, and I'm going to do my best to be objective and factual. Okay, so we're going to start from a really broad perspective, and I know a lot of this is stuff folks here already know, but let's start with some context. A key premise of our founders was that separation of powers was necessary to political liberty. This is a concept that gained traction in the Enlightenment era, in the era just before our revolution. I say gained traction because it wasn't a new idea in world history, but, you know, post, 1066, it was kind of a new idea at that time in the 1700s. And it's inefficiency by design. That's what I've said here. The idea was that we don't want necessarily efficient government. We want a government where political liberty is protected. So we want a fairly inefficient government to hopefully avoid abuse of power. I think that the most influential thinker on our founding fathers on this point of separation of powers was probably Montesquieu. The Spirit of the Laws was published somewhere around 1770, and in this work, Montesquieu built upon this concept that John Locke and others had discussed previously. But Montesquieu felt strongly that separation of powers was essential to political liberty. Not that it was best practices, not that it was a good idea, but that you cannot have meaningful political liberty without separation of powers. And it's important to note what we're talking about here is not necessarily balance of powers, okay? Although I think that the founders and all of us kind of go for that. But I think historically it's accurate to say that our founders were more concerned with separating the powers more than necessarily the three branches being equal. I think that historically it's probably pretty accurate to say that our founders preferred the legislative branch to be the preeminent branch. That's why they put it in Article 1. So, I also wanted to point out before I moved on here, looking at my notes, on this topic generally, we need to keep in mind that our founders, right or wrong, believed more in separation of powers than they did in democracy. They weren't necessarily fans of direct democracy. We'll talk about that a little later. They clearly felt that the powers of the government being balanced and separated and checked was more important than democratic involvement. Okay, so the view from 10,000 feet is that Article 1, legislative branch, legislature makes the law, executive enforces the law, judiciary interprets the law. Oversimplification, but reasonably accurate, I think. As most of us learned in 8th grade civics, we have a bicameral legislature, House and Senate. But what we need to remind ourselves, I think, these days when we're thinking about these issues is that these two houses of our Congress were meant to be very different. The House was designed to be responsive to the people, reactive to the people's desires. It's the only portion of our government in the Constitution for which there is direct democratic elections. So per our Constitution, only members of the House of Representatives are directly elected by the people. The senators were appointed by the state legislatures. That's in the Constitution. Now, it was changed by amendment later, but originally the idea was the House would be the one place where there would be true democratic representation. Because in the executive, we've got the Electoral College. There's a buffer there as well. So the founders, I think it's fair to say, saw the Senate as a mechanism within the legislative branch to slow down the process and make it more deliberative. I think it's also fair to say that our founders probably viewed the Senate as a place where those in power in society would reside. Aristocratic landowners, I think really that's kind of what they had in mind. And in their view, at that time, from their historical context, they believed that if you have a branch of the legislature where the people who are in the top 1% who have been really successful by way of the status quo, if we have those folks in the government who have an interest in the status quo, that will sort of slow the system down and avoid change happening too rapidly. Originally, the senators were appointed by state legislators. That was changed in, I think, the 17th Amendment. Somebody correct me if I'm wrong. I think the 17th Amendment is what changed that, and I think that was in 1912. What's that? Right, yeah. I think it was around like 1912, 17th Amendment, that they changed that to what we have now, which is direct election of senators. And it wasn't really, I'm going to get off into nerd though, it wasn't really because the folks who created the 17th Amendment really believed in democracy. It's that at that time we were having problems with senators being seated because there was so much infighting within state legislatures that just practically folks were not being seated. And so we made that transition. Another thing to be pointed out before we move on to the slide I'm on right now is the Senate, it has to be said, is a remaining vestige of the desire of the framers for the states to have disproportionately more power, for small states to be overrepresented, which they are in the Senate, and they continue to be. A state like Kansas, where I'm from, we have 3 million people. California has 38 million people. We both have 2 senators. So I am way overrepresented in the Senate. All of the Midwest is way overrepresented in the Senate. In our most recent election, there was a lot of desire to make easy explanations about what was going on culturally, and everybody was reading this book, Hillbilly Elegy, and thought that just explained everything. That the coastal elites were paying no attention to the Midwest and rural interests. And I, coming from a rural state, I grew up on a dirt road. I was literally born in a pickup truck. That's not a joke. I was born inside the cab of a pickup truck. Okay, so that's my redneck bona fides. Folks like me are way overrepresented. states like Kansas are takers. We take more from the federal government than we put in. States like California put in a lot and take less than they put in. So the idea that, rural folks are underrepresented, I don't buy that. Okay, I'm going to get back on topic. Okay, so the powers of the legislative branch. I skipped one. Power of the purse, obviously important. All revenue bills must originate in the House. This is why when we have these conflicts about shutting down the government, it's between the House and the executive, the president. Sole power to declare war, but it will be a surprise to most people in this room that the last war we fought was World War II. The last time that we actually declared war was December 1941. So that has lost a lot of its meaning. They can start investigations. Again, the Senate has the power to ratify treaties and to confirm judges and executive department heads. So what we're seeing here is the Senate, again, taking a moderating role, but this time moderating the executive. Again, the framers kind of saw that as the Senate's role. Power to impeach. These days, a lot of questions arise about that. The House impeaches. Only the Senate can remove. So the impeachment that occurs in the House is essentially the equivalent of an indictment. So you indict the person accused, and then you have a trial. So the House impeaches, and the Senate actually tries the president or whomever is being impeached. Only two presidents have actually been impeached and gotten to a trial. Andrew Johnson and Bill Clinton both were acquitted. I've titled this slide, Federalism Limits Federal Legislative Powers, which is kind of awkward phrasing. What I mean is that we have a system of enumerated powers in our Constitution. The 10th Amendment says that the powers not specifically enumerated to the federal government, to the Congress, are reserved to the states or to the people. Again, there was a bias in favor of balance of power shifting towards states, or at least there being a sharing of power. And before the Civil War, really that balance of power was weighted more heavily toward the states. After the Civil War, that changed with the 14th Amendment and the Civil War itself. 14th Amendment said that everyone, if you are a citizen of the United States, you have the right to due process of law. You have the rights to equal protection of the law that a state cannot take away from you. So although originally in the Constitution we have a system of enumerated, limited federal legislative power, the Commerce Clause has been a source by which the legislative branch has been able to extend their power pretty greatly. The Commerce Clause is in Article 1, Section 8, says to regulate commerce with foreign nations among the several states and with the Indian tribes. Now, through Supreme Court cases, there has been a broad view of that Commerce Clause that has been applied. So that's the primary mechanism by which the federal government has asserted much of its current powers as it stands today to legislate in a lot of various aspects of our society. I think the most seminal case here is Wickard versus Filburn. This is a case in which a farmer was farming wheat on his own land, was not selling the wheat, it was not crossing state lines with the wheat, was only using the wheat for his own consumption. He was feeding his animals with it. And he challenged a federal crop program that limited and regulated how much wheat you could produce at the time. He said, this doesn't apply to me. The United States Constitution doesn't give the Congress the right to enact a law that controls how much wheat I produce. And the Supreme Court disagreed and said, no, although there's not direct regulation of commerce here, what you're doing indirectly affects commerce because you are creating this excess of wheat. You're not buying it elsewhere. you're affecting commerce indirectly, and so the Congress does have the power to regulate what you're doing. Okay, and I'm going to skip my First Amendment slides because one of my colleagues is going to be talking about the First Amendment, so I don't want to steal her thunder. But because most human endeavors can benefit from a little bit of the Gospel of Lebowski, this is the only slide I'll show you. For your information, the Supreme Court has roundly rejected prior restraint. This is about all of us. Okay. I will talk about the one other thing I was going to touch on in terms of continuing controversies with the limitations of legislative power, and that's the Second Amendment, which states, and a lot of people don't know what the Second Amendment actually states because it's often, only the second clause is often the only part stated, but it says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the political right tends to focus only on the second clause, the part after the comma, the right of the people to keep and bear arms shall not be infringed. The political left tends to view this right in context of the need for a well-regulated militia. Now, I will say one point that the political right is historically accurate on is well-regulated meant something different now than it means, meant something different then than it means now. So we think of regulation. Regulated in that context was in the context of a regular army and irregular armed forces. So it really meant more of well-trained, well-organized, but it was in the context of a country that did not have a significant standing army. We, at that time, depended on state militias for our national defense, to call them up. And we had a lot of problems in the Revolutionary War and thereafter with these militia being completely untrained. And when we needed them to defend our nation, we really couldn't rely on them. And so the framers saw that problem, and they knew that we needed well-trained troops to defend ourselves. That was the context. Now, the case that most people talk about these days in the Second Amendment context is D.C. versus Heller. And I've kind of just pulled out the main points from the two sides of that case. It was a 5-4 decision. The conservative Justice Scalia wrote the majority opinion for the 5 justices. The key point that they came to was the Second Amendment protects an individual right to possess a firearm unconnected with service in the militia. So Scalia and the other 4 justices felt that the militia clause was a mere prefatory clause. It was not an operative clause in their view, and we can just kind of see that as historical context and really don't have to give it legal effect. The 4 other justices disagreed. Stevens countered, when each word in the text is given its full effect, the amendment is most naturally read to secure to the people a right to use and possess arms in conjunction with service in a well-regulated militia. So I'm running out of time. I've got too many slides. We've got a short amount of time. Last thing I'll say about this is a lot of people look at D.C. versus Heller, and they think that it was the end for gun regulation in the United States. It's not. That's an overstatement, I think. While it's a big deal that the Supreme Court has said that there is an individual right to keep and bear arms unconnected with the rest of the amendment, they also said that it is tied to the traditional purposes, which are self-defense and defense of the home. And they did draw a distinction between traditional self-defense type weapons and what they call weapons of war. And there have been several circuits that have taken the analysis from D.C. versus Heller to uphold regulation on firearms like AR-15 assault weapons that are designed to kill the most amount of people in the shortest amount of time, saying that these are weapons of war, and so there is not an individual right to keep an AR-15. So, there's still a lot of jurisprudence to be had on these topics. So I have a lot more slides, but I'm out of time, and I need to take at least a couple minutes for questions. Does anybody have any questions? Yes? Okay, can you state your question again? Okay. You mean at the congressional level? I think the current makeup of the Congress is strongly bent towards states' rights and federalism. There's an organization, strongly bent towards federalism, strongly bent towards state rights. There's an organization called ALEC that works at not only state level but the federal level, and works in conjunction with those two and creates legislation meant to limit government power generally, and most importantly to limit federal power. It's most often their legislation is actually used at the state level, and it's kind of a consortium of corporate interests that are behind that, and they literally write legislation with their legislator members. But they write model legislation, which they then introduce in the various legislatures across the United States and in the Congress. All of those are bent strongly to not only limited government, but states' rights as opposed to federal legislation and legislative oversight. Other questions? Yes, ma'am. Well, I mean, that's certainly a fair argument to make. One that I would, probably tend to agree with. The slides, a lot of the slides that I'm not going to have time to touch on today, deal with what I call corporate super entities, which is another limitation on legislative power that has developed through Supreme Court rulings over time. These are kind of the key Supreme Court rulings that have occurred over time that have led to the situation that we're in now. Originally, corporations, just really quickly back up. Corporations are essentially government creations. Okay, so when you have folks who say that they're libertarian but also pro, corporate power, not necessarily consistent. They are government creations. They were originally, corporations were chartered just for public benefit. So if you have a group of people who are going to build a canal or a bridge, the government would charter a corporation to say, okay, that's a publicly beneficial endeavor, and you're going to be able to create this entity which has certain legal protections, never dies, and your assets will never be at risk in terms of liability because you're going to perform this beneficial function. Now, over time, that has evolved. You can have a corporation for obviously any purpose now. And over time, I don't know if you can read these slides, but through Supreme Court decisions, the Supreme Court has essentially decided that corporations have most of the fundamental rights that humans have. The only one, of the fundamental rights that we have under the Constitution, the only one that springs to mind that corporations definitely don't have are Fifth Amendment rights. All the others, they have. Most importantly, with the most recent decision, they have First Amendment rights, and the Supreme Court has decided that spending money on political campaigns is akin to speech, and so the legislature cannot essentially regulate a large portion of those activities. Okay, I'm out of time. Thank you.